Good afternoon, everyone. We're just going to give it a second to let folks fall in. I see the attendee number going up, so we'll just give it a second. Great. Well, welcome everyone and good afternoon. And thank you for joining us today at the Fines and Fees Justice Center's webinar on our recently released policy documents. These policy documents are what we view as first steps in the efforts to reform the use of fines and end the use of fees in the criminal justice system. Today, we will learn a bit more about our guidance, why we issued it, and some of the key things in the documents from FFJC's Senior Policy Counsel, Chanel Johnson. Chanel joined FFJC in March of 2020. Prior to joining FFJC, Chanel was a member of the Council of State Governments Justice Center's Juvenile Justice Team, supporting the states in development, adoption, and implementation of legislative reforms. She also worked for the Governor's Office of Crime Control and Prevention in Maryland. We are also very fortunate to be joined today by three panelists who are working on the issues of fines and fees in their respective states. We have some who all accomplished some impressive wins, but have also had to go through some significant obstacles along the way. Emily Garrick is the managing attorney of policy and advocacy at the Texas Fair Defense Project. She joined TFDP in 2014 and helped to develop their criminal debt initiative and freedom to drive initiative. Emily leads TFDP's legislative and policy work. She has also helped to pass legislation to combat modern day debtors' prisons, establish the right to ability to pay hearings, and expand access to debt waivers, and restore hundreds and thousands of driver's licenses that have been suspended for inability to pay fines, fees, and surcharges in the state of Texas. We also have Sheba Williams from No Left Turns, a Virginia-based nonprofit that Sheba started to support system to be a support system for those with justice and court involvement. Her nonprofit quickly evolved into a day-to-day fight for removing the policies and stigmas around past conviction. Sheba started No Left Turns in 2016 after her expansive career in community service experiences made her realize that so many of the people that she was coming into contact with had something very specific in common with her, a felony conviction. Finally, we have Rob Pugenglass, an attorney with the Virginia Legal Aid Justice Center. Rob spent several years working on court debt and expungement cases at Iowa Legal Aid. His career also includes working on criminal justice policy as a public defender in the state of Virginia. So today's agenda, we are going to go over FFJC's new policy documents and then pivot into a conversation with the three panelists about the issues of fines and fees, reform work, in both Virginia and Texas, and how these policy documents can be used to help advance the issues that we're all working on across the country. Right now, so the chat function, just some housekeeping stuff, is not accessible during the webinar, but there is a Q&A function, and so you should be able to put any questions that you have in the Q&A function, and we'll be checking that throughout the webinar, but we will have a portion of this webinar at the end that is dedicated about 20 minutes or so to question and answer. So if we aren't able to get to them during the moderated conversation, we will be pulling for those questions and answering them at the end of the webinar as well. So thank you for joining, and we're going to get started because there's a lot of information to pack into this 1 hour, and I'm going to kick it over to my colleague, Chanel. Chanel?
Thanks, Priya. Good afternoon, everyone. So like Priya said, I'm going to just provide a little bit more context and background on how we settled on developing policy guidance on the ability to pay, payment plans, and community service. I'm also just going to provide a very brief overview of what we actually included in the guidance on each topic. So we actually spent quite a bit of time going back and forth on which topics to include, what guidance we wanted to provide. Ultimately, we settled on ability to pay first. And the reason that we wanted to start with ability to pay is because we've seen governments and courts using ability to pay as a solution, regardless of the advocates' efforts to push in a different direction. And many jurisdictions are doing ability to pay without any guidance or standards for what ability to pay actually means and what it should look like. So while we don't agree with ability to pay as a policy solution, we felt that it was necessary to provide standards and better practices for jurisdictions that are either planning to begin developing such policies or have already started to do so. So our thought and our plan for putting this package of guidance together was that when advocates are having conversations on ability to pay, we wanted them to be able to have something to point to. We wanted them to be able to show policies that show exactly what is necessary to do anything close to a meaningful ability to pay. So we then decided to include payment plans and community service because we think that these two topics should be dealt with collectively as a part of ability to pay determinations. So we see these three topics working together in the way that a court would do an ability to pay assessment and then waive or reduce fines and fees appropriately based on the information from the assessment. And then at the individual's option, then put them either on a reasonable payment plan or then convert the reduced amount to community service hours. Just like with ability to pay, we're not necessarily advocating for payment plans or community service as policy solutions, but we do understand that in order to have meaningful ability to pay determinations, we have to consider payment plans and community service. Also, we think that these three topics work well together to ensure that there is fairness in the criminal legal system. They also provide consistency with what the constitutional requirements are for assessing legal financial obligations. And we think that they can help to improve court efficiency. Another key point that we want to emphasize is that we do believe that jurisdictions should be eliminating criminal justice debt. We definitely believe in that as a solution. However, we understand that many jurisdictions are not in a place where they can do that, and that it may be a substantial period of time before we are there. So in the meantime, we see this guidance as tools to help mitigate some of the harms caused by fines and fees as we continue the work towards eliminating government reliance on fines and fees. So moving into the actual content of the policy guidance, like I said, just gonna briefly touch on some of the major concepts and ideas that we address throughout the document, starting first with ability to pay. First and foremost, courts have an obligation to make a determination of an individual's ability to pay, and that determination should be made before fines and fees are assessed. Also, there will be circumstances and individual characteristics that may trigger a presumption that an individual does not have an ability to pay. So to that point, we included in the guidance a list of circumstances that we think trigger that presumption. It's not an exhaustive list, but definitely things that should be considered at a minimum. And where those presumptions do apply, judges should waive fees and reduce fines to the lowest amount allowed within their discretion. If a presumption of the inability to pay does not apply, we recommend that courts use the Department of Housing and Urban Development's very low income limits to determine the amount that should be assessed. And within the document, you'll see that we provided a link to those standards, as well as provided a little bit more information both in the actual document and in the background document about how to apply those standards to determine what amount should be assessed. But we felt that it made sense to use the HUD standards because those very low income limits are already out there, jurisdictions are already familiar with them, and they're tailored to every jurisdiction. So moving into payment plans, after fines and fees have been waived and reduced, individuals should have the option of utilizing a payment plan to pay whatever the balance is that remains after fines and fees have been waived and reduced. And that should be offered without requiring any additional fees or down payments. We also talk a little bit more specifically about some payment plan policies around the maximum monthly payment amounts that should be required, consolidating debt where there are multiple open cases within a jurisdiction, as well as forgiving debt after a specific amount of consecutive payments. Lastly, on payment plans, incarceration extending probation, denying services, or suspending licenses should not be a punishment for missed payments. So we do provide a few alternatives for how jurisdictions may want to handle missed payments instead of relying on those punishments that we know can have some very significant collateral consequences. So the last section is community service. And again, community service is not a policy solution, but when it is, when the individual is given the option to self-select into community service, when it's assigned with consideration for an individual's family, work, and education obligations, when it's credited at a reasonable amount and defined broadly to include a wide range of activities, community service can offer an appropriate alternative to complying with legal financial obligations. So we do include some examples of the type of activities and the individual factors that should be considered in order to determine what should qualify as community service. Again, not an exhaustive list, but things that should definitely be considered. Also very important to ensure that individuals who do choose to participate in community service are credited at a reasonable amount, a reasonable rate. So we do provide some options for how courts might want to go about converting those fine and fee amounts into community service hours. So the very last thing that I will mention before I turn back over to Priya is the background section that we included at the very end of the policy document. And this was really just intended as a place to point to some of the examples of jurisdictions that are already doing some pieces of some of these things well. Unfortunately, there is no place that's doing everything and there's no perfect model, but we did think that it would be helpful to see kind of the landscape and what is already happening in this space. So Priya, I'll turn it back to you.
Great, thanks so much, Chanel. And so before we get into the panel, there was one question that I think, I believe Chanel really did answer it in her question after it was asked, I mean, in her opening remarks after it was asked, but I just want to re-emphasize that these policy documents that we issued, we really see as a harm mitigation tools, ability to pay, payment plans, community service. And so the reason that we continue to emphasize that we as an FFJC do not necessarily categorize these as like policy reforms or really meaningful policy shifts is that the use of fees themselves in the criminal justice system is something that we do not believe should exist to begin with. And so to sort of get into the conversation and the nuance around ability to pay, it's sort of this presumption that as a matter of policy, the use of the system the way that it is something that is okay or is good policy. And that is not something that we think. We think that fees need to be eliminated from the system. And then when you look at fines, that they need to be equitable, they need to be tailored to both offense and to individual. And a lot needs to go into the evaluation of how, when, and why to use a fine. And so without really dealing with that, and we'll get a little bit of that conversation about pushing for very, very significant and meaningful shifts from government's use of fines and fees in the system to something else entirely. But currently, this is how the vast majority of our systems across the country exist. And so people are being harmed and have been harmed for so long with the way that the system exists that there needs to be some tools in place to take off that pressure to deal with the system as we've created it while we continue to really shape and transform the system as we'd like to see it. So that's where we're making that distinction between policy reforms and what we really think need to happen and trying to sort of deal with the problems as they are with us right now. So hopefully that answered your question. So let's dive into the question and answer. We're going to start here with Emily. So welcome, Emily, and thanks for joining us. In 2017, Texas passed an ability to pay statute. Right now, it would be sort of considered as one of the better, ability to pay statutes around the country. Partly because there's a lot of language in that statute, and we say that because it speaks to some of the criteria and broader definitions of payment plans and waiving and reducing that Chanel pointed to in our policy documents as well. But we know that it's a long way from perfect. So I would like to hear a little bit about how your ability to pay statute in Texas sort of came to be, what was left out, and sort of, of the nuance behind how all of that happened, and where you see things.
Yeah, absolutely. So yeah, it's great to be here. Thank you for having me. I have to say, I do think it's kind of sad to hear that Texas has one of the better statutes. We did pass legislation in 2017 and 2019, and it's certainly better than what we've had, and it has had significant impact, but it is far from what I would call good. And from working on that legislation and seeing the impact of it, I really just want to emphasize, first of all, how important the waiver and reduction piece of all of this is. I think, the Texas Fair Defense Project, we do both policy and direct representation in courts all over the state. And something that I'm sure most people on this call have noticed is that it's really, really expensive to be poor. So our clients often owe thousands or tens of thousands of dollars in unpaid ticket debt. And it's not because they're worse drivers, it's because they can't afford to pay right away. And that just ends up being a lot more expensive for a few reasons. There's a feedback loop where you lose your license and your vehicle registration because you can't afford to pay the tickets. Then you get pulled over more often. Every time you get pulled over, you get multiple tickets. And each one of those tickets is at least 3 times more expensive if you can't pay right away. So it just adds up very, very quickly. And so payment plans and community service on their own, I think that there's an instinct for legislators to focus on that, but they don't do much for equity if you don't emphasize reductions and waiver. Because if you're just converting what somebody owes into a payment plan or community service plan, you end up having people who are on payment plans or community service plans for years until they eventually miss an installment and get a warrant. And so I think that is just really something that we should be focusing on a lot. And just to give a little bit of a summary of what this legislation did. So in 2017 and 2019, we doubled the credit rate for community service, broadened the definition and access to alternative sentencing, and we made it so that courts can't require a down payment or money bail to clear a warrant or see a judge, which have been very common. And courts now have to consider ability to pay and consider alternatives, including waiver at sentencing. But that's kind of meaningless for Class C cases where you don't have a lawyer and are almost never sentenced by a judge. So another thing that we have in there is that judges also have to reconsider your sentence if at any point you give notice to court staff that you're having trouble paying. And we now have guidance to judges about waiver with a statute that outlines factors they should be considering, including disability, childcare, transportation issues, and housing insecurity. So those are some of the things that have made it in. And I do think they've had an impact, but it's been really hard to actually implement. And a lot of things did not make it in that are in the policy guidance and that we really tried to get. And I think that's another reason why working at the local level is so important, and actually going into courts and representing people as well. And I'm hoping that, we've passed something every legislative session recently, and I'm hoping we can just keep chipping away both at the state and local level.
Before we get into some of maybe the challenges on the implementation side that you referenced, what were some of the things that you tried to sort of get into this ability to pay from a policy standpoint that you weren't able to, that you may now try to go back and sort of chip away with?
So I think one of the main things was right now the statute says that judges may waive in these circumstances, but it doesn't say shall. We've written it so that really the only real option is to waive in these circumstances, because we've written that community service is not appropriate, like when these different factors apply, and we've written it so that if you can't afford to pay, or if it would cause a hardship to pay, then they should be considering alternative sentencing, and the only real option then would be waiver or reduction, but it doesn't say shall. And the reason for that is because it's really difficult to change a may to a shall for judges. That is just something that is hard to get past and that there's a lot of resistance to. But because it's not very clearly written in the statute, it does make it much harder to be getting waiver, which is still very rare.
So on the implementation side, this statute was passed in 2017. What have you seen as sort of the challenges and the shortcomings on the implementation side? And as sort of the flip side of that, has anything, in your opinion, actually worked well, or have you seen improvements and seen progress? And so where is that right now?
Yeah, so it's a really important question. So Texas is really big. It doesn't have a centralized court system, and there are thousands of courts that handle fine-only offenses only. And none of these courts appoint attorneys, and many of the judges aren't lawyers either. And so oftentimes you get courts that are relying on clerks to tell them how to do things, and the clerks will often say to do things just the way that they've always been done, and there's not a lot of education around how statutes have changed. And this has been interesting. In 2017, I feel like everyone knew about this legislative push, but there wasn't a lot of detail paid to what was actually in the legislation. And so the statute around jail time for inability to pay, we already had for a very long time, since Tate v. Short, a statute on the books that said you can't jail someone for inability to pay. But it was happening constantly. We were constantly representing people who were in jail for weeks or months for inability to pay traffic tickets. And this legislation did very little to change that because we already had pretty good protections in law. But everyone seemed to think that the law had a lot to do with jailing for inability to pay. And after the 2017 legislation passed, jailing for Class Cs went way down. It's very, very rare now. There are only a few courts that we found that are still putting people in jail and sentencing them to jail for inability to pay. But on the other hand, some of the more in the weeds parts of the legislation are not being followed. Some courts are still requiring down payments to get on community service, to get on a payment plan, for example, or to see or pay a money bail to see a judge, which is no longer allowed under the statute. And so I would say the biggest thing for us, because you don't have attorneys in these cases, is we have put together a pro bono network of attorneys to go into court and represent people. And I think just doing that often makes a big difference, because these courts often aren't used to anybody coming in and representing people who don't have money. And that can often change a lot of practices just on its own.
Thanks so much, Emily.
So bringing our panelist, Robin Sheba from Virginia, into the discussion. Sheba, can you talk about the harms created by fines and fees and how people are experiencing the challenges when they can't pay fines and fees that are assessed against them?
Yes, good afternoon, everyone. Thanks for having me. So getting into it, the most significant harm is economic impact on individuals and families who can't afford to pay. So currently, even with the changes in our laws where you're no longer able to suspend people's licenses, if you have anything other than just fines and fees costs, if, for instance, the judge suspended your license for a 3-day period or a 6-month period, you then have to pay a reinstatement fee at DMV. You have to deal with the loss of transportation, and our transportation systems in Virginia are not great. If you live anywhere in the state, really, our transportation systems are horrible, which not just takes a toll on income, but it takes a toll on your time. Navigating a bus system here takes anywhere from 3 hours, where it would be a 15-minute drive for most of us. So if you lose your license as a result of inability to pay, when you're not covered by the law that changed it, that takes a lot away from your income, your bottom line income. You are unable to participate in certain jobs if they're not in range of your accessibility because of fines and fees. The many things that come about, you have to make a decision sometimes when you have fines and fees to either pay or deal with your basic needs: food, housing, entertainment, time with your children. Sometimes you have to make a decision about whether you can pay this fine to stay out of jail, because Virginia will issue a bench warrant and say ability to pay was not complied with. I had a young lady that I assisted recently who wanted to vote. So you're put on parole and probation until you can pay all of your fines and fees. A lot of times you're not released from parole or probation, which means she was also disenfranchised. She was not able to participate in the voting process. And even though our state says that they can no longer use that as a means to disenfranchise people, if you keep them on parole and probation, there's the workaround to that. So she ultimately ended up paying in full. But because she had a bench warrant issued for failure to comply previously, because she couldn't afford to pay because of losing her job in the middle of this pandemic, her parole officer made the decision that we couldn't get her back into court until after the deadline passed to get her registered to vote. Therefore, she wasn't able to participate in this past election. That is a very real trail and train that happens to people who have fines and fees. Then we started a thing in 2019 where courts were deemed to say, well, let's look at the totality of the picture and decide what's affordable and set up payment plans or community service in lieu of some of these fines. So none of our courts communicate. If you have multiple fines in multiple jurisdictions, you are paying whatever that assessment says in each individual locality. They're not looking at if you have fines in 3 localities that need to be combined as one. You have to do an individual assessment in each court. And community service, as it stands, is still like charged at the federal minimum wage, which is $7.25 an hour. Imagine, doing community service in lieu of inability to pay, and it's still being capitalized on at that very minimum amount. So there's a ton of things that can lead to fines and fees. The things that a lot of people don't see is if you're trying to purchase a home, that credit to debt ratio can harm you. If anything goes to collections, that's not something that doesn't show up on your credit report. Now, when it goes to collections, it shows up on your credit report, and that takes away from your credit worthiness. So there's so many things that can impact, but those are just a few examples.
Thanks, Sheba. Rob, Sheba mentioned, inconsistency across jurisdictions. Can you speak to that a little bit? What are you seeing? Are fines and fees being waived and reduced in courts right now? And is it consistent across the state?
I think it's fair to say that it's not consistent. Virginia is one of those states without an ability to pay statute, or really without a court rule as well. And there are certainly judges out there who are not thinking about ability to pay at sentencing. In some jurisdictions, defense counsel will raise ability to pay, and when judges are confronted with it, then they have to address it. But I think the gaps in consistency are a function of whether criminal defense lawyers are making those affirmative ability to pay arguments.
Yeah, we hear that a lot from states, that inconsistency is an issue in their states and their jurisdictions. And, just overall, the system of fines and fees as it currently exists, causes harm for a lot of people, probably now more than ever due to COVID and financial challenges that everyone is facing. So Sheba, can you talk a little bit about how we balance the need for and the desire to transform the system as a whole, which could take a bit of time, with the fact that people are being harmed and need help right now? How do you see harm mitigation tools, like the guidance that we put together or others, how do you see that fitting into your reform efforts?
So definitely stopping the ability for localities to incarcerate individuals for inability to pay. That is a huge thing. Our Virginia State Crime Commission had a meeting yesterday talking about ending mandatory minimums. And what stood out was driving on a revoked or suspended license takes you into habitual offender status. That is one of the top offenses that you get a mandatory minimum sentence for. That has to stop. Mandatory minimums should have never existed. But the mere fact that if you lose your license because you couldn't pay in the first place, and you continue to drive because you have a family or you have to survive, you can be criminalized again, over and over and over again. So if we look at a total picture of what a person can afford, or if they can even afford things, that would be something that could reduce some of the harms with people. And it's been long term. It's been something that's gone on for a very long term. Breaking through the barriers of ensuring that fines and fees are not utilized to take away people's licenses was something that Legal Aid Justice Center was successful in, but it has to go even further. We have to say that by no means can we use driver's license suspension for non-driving related charges. And also, it takes a total look at not just income on a sheet of paper, but the family structure. It takes a look at the whole household. There were times when I was paying fines and fees and managing a household with 3 children under the age of 4, and I was paying $1,300 a month in childcare. So even though the court said, oh, $50 is sustainable, that is the lowest amount that you should be able to afford, it was a burden at times. And a lot of people say, oh, $50 isn't much. It isn't much if you have disposable income to, use, but if everything goes towards paying bills, and if you get to a point where you have a conviction, a lot of times you're burdened away from certain housing options, which means that like in affordable housing or public housing, sometimes you're not able to get that. So if you're living in a private house, you're paying all of the bills. You're paying the electricity, the water, nothing is included when you're living in a private home. So none of that is taken into account. And if we look at the policies and the recommendations of this document, if we go by ability to pay, and then we set up a payment plan based on each individual's ability to pay, or we look at the options for waiving for people who are receiving public benefits or receiving SSI or become pregnant or totally disabled, that would ensure that we're not further criminalizing and harming the communities that have been impacted by this for years.
I think you make some excellent points, and a lot of the points that you brought up about what to consider, what really should be evaluated is more than just like a checklist on a piece of paper. Where we have seen that in some states and some jurisdictions where giving people sort of the benefit of the doubt, the intentions are good, the thought process and what they're trying to achieve is good, but it doesn't really get you what you're looking for. It doesn't really alleviate the real burdens and harms because it's not looking at it the right way. And having heard this from many jurisdictions and places across the country and places where people were considering options, we really try to include those factors in this guidance so that it at least triggers the thought process of, oh yeah, that's a great point. People have childcare. They have, in certain places in Virginia and in New York and all these places, the childcare is extremely expensive, right? That's a huge part of what people pay. Housing costs are extremely expensive, right? So there's all these factors that you're just sitting on a bench from your perspective of how you live your life. You're not really appreciating what is happening in the daily lives of so many people. And now, as we're going into new legislative sessions, with the financial, economic, and family harms that have resulted from COVID-19, none of this is new, but all of this is worse, right? Every single thing you said today, it's amplified in every way. More people, so more homes, more communities have been, ravaged by COVID-19, and businesses have closed, and we're still a long way away from anything sort of turning in the direction we'd like to see. And people are hurt. So initially in the sort of initial shutdown, lockdowns, we saw some things go into place, some moratoriums, some trying to alleviate, but we haven't seen those hold up over time. We haven't seen that even though nothing else has changed, people are expected now to pay their rent, to show up in court, to do all of these things. And, we'll talk a little bit later about how, we're trying to address COVID-19 and fines and fees. But I think that all those points that you said are really exacerbated now and really challenge us to think about reform and sort of harm mitigation at the same time as we move forward in our strategies. So I want to talk to Emily and Rob a little bit about driver's license suspension. So this came up in some of Shiva's comments, and it's come up along the way. As of today, or when all these sort of laws officially go into place, we will have, now we've had 2 new states that have joined us in the past week, New York and Michigan, who have ended the practice of driver's license suspension in their states, and Michigan for both failure to pay and failure to appear. And it's really exciting. We're seeing more and more states moving in the direction. In 2020, that would make 7 states that passed laws that ended this practice in their states, or at least ended it in a significant way in some of the states where we can't fully get them over the line. And we're seeing momentum. We're really hopeful that in 2021, that is going to continue. We're going to see more states going in the direction of Texas on a state level, at least, and Virginia as well. But this question of ability to pay, and as advocates are working in their jurisdictions right now of trying to change and reform the practice of driver's license suspension, while also talking about these issues of the underlying fines and fees. And now we're adding this layer of ability to pay. And at least from FFJC standpoint, and I know this is pretty widely shared in the advocacy community, that ability to pay is not the answer to driver's license suspension. So that driver's license suspension as a consequence for unpaid fines and fees needs to end, period. And so that just needs to stop. And then we need to start having these conversations about or at the same time, but sort of separately in their lanes, that what are we doing with the fines and fees themselves that led to the driver's license suspension. So how do you all, in 2 places where, in Texas uniquely, because it's on the state level been repealed, but there's still a mechanism in place on the local level. Let's start with you. And in 2017, you passed ability to pay, but you passed the driver's license suspension bill in 2019 now. How do you think about that in terms of strategy of trying to abolish the use of driver's license suspension, but then you have this other layer of ability to pay, and that ability to pay doesn't become the solution to driver's license suspension?
Yeah, so I think I have to give a little bit of background on what programs we have / had in Texas. So we had something called the Driver Responsibility Program, which had 1.3 million suspensions in Texas for inability to pay surcharges. And that, just a little bit of history on that, because I think it's relevant. So that people have been trying to get rid of that, and it was a very hated program in Texas for over a decade. Pretty much as soon as it was passed, and it was like a revenue stream for trauma hospitals due to budget shortfalls in 2003. Pretty much since it passed, it was very controversial. Everyone hated it. Judges would come out against it. Employers would come out against it. All of the people that you want to come out against it. People who didn't really understand what it was still thought driver responsibility program was like a dirty word, and everyone hated it. The problem was that, we had to find replacement funding for the trauma hospitals. That's where the money went. But in, I think it was 2015, I'm not sure, they implemented an indigency program for the driver responsibility program, where if you could show that you made under 125% of poverty guidelines and sent that in to the state, then they would lift the suspension. And I think it's interesting that that didn't seem to slow down the momentum for getting rid of the driver responsibility program. At that point, I think there was enough momentum. Everyone hated it enough, and even the trauma hospitals were coming out and saying they wanted a different source of revenue, that people still were going to want to repeal it. So that passed in 2019. 1.3 million suspensions lifted, but about half of those people still can't get their driver's licenses because of other suspension programs, the most common one being one where local jurisdictions can put a hold on your ability to get your license or renew your license if you haven't paid fines and costs. And I think that full repeal is what we need for the driver responsibility program. There were some efforts to just, make some minor changes, but we were not willing to settle for anything less than a full repeal, because otherwise, the indigency program that they had, it helped some people who had a lawyer and can do it, but the vast majority of people who are being affected couldn't take advantage of that program, and we're still going to have their license suspended. And we see the same thing for this driver's license renewal program now. We have an ability to pay statute, but it hasn't really cut down on the number of license holds under this local program. And so what we're doing right now, since it's very difficult to repeal it at the state level, is going from jurisdiction to jurisdiction and convincing them that this is a very harmful program that has no upsides whatsoever, and they really need to get rid of it. So yeah, I would agree that it really, ability to pay can sometimes be helpful, but you have to be careful about how you use it and how it's going to impact momentum going forward.
Thank you. Rob, do you have anything to add to that?
No, I'm gonna defer to Amy.
That's great. So that's great. And we have a few questions in the Q&A. So let's start with that. And I think we'll start, even though it's not in order, but we're talking about driver's license suspension here. There's a question about provisional and occupational driver's license as an alternative to elimination. So I think there's a couple of layers here. One, there are already a lot of states that have restricted license, occupational license are called sort of different things in different states on the books as a mechanism for an alternative. What we've seen is that one, they never get issued. It's super rare that they get issued. And the large part of that is because there is a hearing, it's a process. There's a lot of, it's not just like you go down and get one. So that is its own process. The other part of the restricted license is thinking about how the enforcement of a restricted license really works, right? Like there are conditions in which you can, if you do get a restricted license, you can operate it. It is to go to work, come back, whatever the sort of parameters are. But if you get pulled over in that moment, how are you going to prove that you were doing something within and do you want people in the moment when they've been pulled over by law enforcement trying to get into this back and forth about how they're legally allowed to be doing the thing that they're doing in the moment when that doesn't fit within what the police officer thinks? And everyone's job, especially now in gig economies and people sort of having jobs look all kinds of ways, what does that even look like anymore, right? And so I think that while it seems like, and we get into this with a lot of fines and fees issues, where the solutions seem like they make sense, like when we first think about it, when we really start to peel back the layers on it and sort of think about this in the implementation of it, kind of find that it, in a lot of ways, can create even bigger problems than that we were intentionally trying to move away from. And so that's what we've seen with restrictive licenses. That's why we push for just reform all wholesale. And just even getting now into the question of like, is that how we want to use law enforcement? Is that what we want to be putting on the plates of law enforcement officers and into this much larger conversation where what are we asking of them to do? And, I think for a lot of people, this is not one of those things. And then we also get in, I want Amy to sort of weigh on this of, there are a lot of folks who get on payment plans and, you can get your license back, and there's different ways that this shows up, but people from a variety of reasons may miss a payment, right? And so what can happen when circumstances, and especially people living check to check, week to week, day to day, where the circumstances pivot so quickly, what happens there? Amy, you want to weigh in on this a little bit?
Yeah, hi, good afternoon, everybody. I'm Amy Willard. I'm Director of Policy with the Legal Aid Justice Center with Rob in Virginia, and worked on our legislative campaign here to repeal driver's license suspensions for court debt. I wanted just to say a couple of things about the question on provisional and occupational driver's licenses. And this is going to vary state to state. But I think, when we started here in Virginia, our driver's license suspension scheme was automatic. It was built into the code at a certain point. And so there actually was no hearing. There was no moment for people to be able to ask for a restricted license. And so that was one barrier, even to thinking about using that kind of tool. I think for us too, we just didn't want to further entrench using driver's licenses as that kind of tool. And so to create these kind of workaround systems just seemed to authenticate the ability to use licenses in that way, in a way that we didn't want to further, put into our system. The other thing that came up in Virginia is, we looked into, when we were looking at all of the license suspensions, we pulled data on people who needed commercial driver's licenses for certain careers. And in Virginia, at least, you cannot get a restricted license that is a CDL. And I'm imagining that's true. In some other states, it may vary, but there was no way for people who were bus drivers or truck drivers or construction workers to get a restricted license and still be able to be employed. So I just wanted to make that point. And then, yeah, on the payment plans, you know, I think part of what happens that we were seeing in Virginia is that this payment plan policy structure assumed, you know, used sort of a normative assumption of like this consistent monthly income that people would have, that you could just carve out, you know, $50 a month from this regular paycheck you were receiving. And that just wasn't, it's just not the case, especially for a lot of our clients. Your income is going to vary, the bills are going to vary, and it's really reasonable to miss a month. And our system was just set up as a trap that as soon as that month was missed, the license suspension issue was triggered and people would sort of fall in and out of that status, right? And so there was even this sort of confusion about whether the license was suspended or not because of how that could change over time and so quickly over time. So those were just a couple of the things that I wanted to bring up in that regard. And that's why we really just sort of emphasized the wholesale reform needed to happen, so that driver's license themselves just needed to be pulled out of that policy conversation as a tool because it just became too complicated to make it work for people across the board.
Yeah, that's great. Thanks so much, Amy. Emily, I want to ask you this question because of how your statute's written and you've had a couple years with the courts. The question here is, what are the best ways to ensure that judges comply with the ability to pay determination requirements? So, you know, I know you might have an interesting answer for this, but how do we, if we can get a statute, if we can get court rules, like how do you make sure that they're being followed in the way that they're intended?
Yeah, so some of the things that you really want to happen, like I'm assuming that you have a court system that isn't centralized, and it's huge and tons of different courts that are their own, have all their own rules. I think, you know, you can have, like we have judicial education organizations, but I haven't seen those making a huge difference, especially in a lot of these jurisdictions that are more, well, actually, no, even the larger jurisdictions are still not following the new statute. So yeah, it's hard. I would say that, again, having an attorney go and actually file things and represent people who can't afford to pay, that has been the one thing that I've seen making a huge difference and can change even things on the policy level without doing any policy advocacy. Just because in most of these courts, you know, so because they don't appoint attorneys, this is going to be the first time that an attorney is ever coming in and saying, no, this is this person's rights. You need to do X, Y, or Z. And we've had a lot of jurisdictions that initially started out hostile to that and then started changing a lot of their policies and ended up doing, you know, dockets for ability to pay, and stopped doing the, you know, they had been saying, if you don't give us a down payment, then you can't get on a community service plan or a payment plan or see a judge. And they just changed those policies for everybody if you just represent a few people. So I would say, yeah, you have to actually go, you have to observe court, you have to, you know, talk to the local officials and do the local work as well. Oh, and judicial complaints, those are a thing you can do. We've done some of those and those have been somewhat effective.
Great, thanks so much, Emily. So there are a couple of questions here that are really getting at the issue or question around the use of day fines, if we've seen that, if people are actually considering that. I'm happy to give sort of the FFJC's thoughts on that, and if folks have, you know, other thoughts on it, please share. You know, I think the short answer is in the US, we have not seen, you know, these day fine models like be tested and work. There was a period during the 80s where there was a pilot program and it wasn't with like traffic tickets that looked promising, but it was really sort of right before the age of you know, law and order, tough on crime, all of the things that shifted us away from potentially going in that direction. But what we are seeing now is more an interest in exploring the idea of like, what would a day fines model, especially in the traffic world, look like? There have been some bills introduced across the country to pilot ideas. There are more and more jurisdictions that are looking at that and trying to figure out how they can test ideas in certain type of infraction areas. And, I think that's promising, because this is an area where, it seems intuitive that there's something to it, but how and exactly what that looks like is the question that we need to answer. And some of that is going to take a little bit of trial and error and exploration to figure out, how do you do that? Ability to pay at one point in all of this conversation seemed like the answer, and we learned it was not the answer, right? And so that could be a similar feel for day fines. And I mean, sort of the short answer, we don't know yet, but there is definitely more interest in pursuing these ideas. We have a couple questions. So one, there's a litigation question that came up here. I know that I do not feel adequately sort of entrenched in litigation, although I technically am a lawyer, to answer those questions. But the Institute for Justice is really the folks that are really well versed on this excessive fines clause and the intricacies of this argument. So one, we are happy to put people in touch with the folks at IJ who know the answers or can really weigh in more effectively on the answers. But on a very broad level, the discussion is happening. That conversation is happening. Those ideas are being generated, and folks are really talking about this excessive fines clause and what can be done in this space. And so, a little bit of TBD on where things are with that, but happy for the person who asked, if you want to get in touch with us after, to connect you with the right people to have the conversation around that. While I'm looking through the question, Chanel, do you want to just tell folks about the new COVID site of COVID-19 fines and fee sites? And I'll just check these question and answers a little bit more.
Sure. So just a few weeks ago, we actually launched a microsite on our, you can access it from our Fines and Fees Justice Center page. And the goal of the website is really just to highlight some policy recommendations and budget solutions for dealing with fines and fees now due to the impact of COVID-19. So we have a tracker where we started tracking at the very beginning of COVID-19 all of the positive reforms that are happening as relates to fines and fees policies during the time of COVID-19. We also included a Hall of Fame and a Hall of Shame that kind of it highlights some examples of policies that we think are really good and some that we caution other jurisdictions against following. We have a number of policy recommendations, like I said, for how to deal with fines and fees, like what should be happening around fines and fees at this present time. And we've also collaborated with the Center for Budget and Policy Practice to share some of their information and their research on some alternatives to fines and fees in this space.
So there's a question on here about whether we're looking at solutions of lever DOJ grants, the pressure from the muni bond market, DOT funding restrictions when it comes to driver's licenses. I will say that the short answer of that is a lot of those conversations have happened, continue to happen on the federal level. This is really very much a state and local issue. The use of fines and fees, how it shows up, it is happening. So it's different in every state, and even within the states, we're finding every jurisdiction within the state is doing things differently. And so there are conversations about, well, how can you incentivize, what, sort of carrot and stick when you talk about grant funding is available and how those tools can be used, and whether or not this new Senate and this new administration, are there opportunities to think about these things differently? So those conversations are happening, and I think a lot of advocates who work in the federal lobbying space or having those conversations and figuring out if there are things and ways to pull some of those levers where we can, you know, put pressure on the reform on the local level. I think Amy is answering this one. And so there are questions here about where you can find the traffic day fine bills. So the Fines and Fees Justice Center has a clearinghouse on its website, and we try to put everything that we find in the field, like bills, research, data, in our clearinghouse. We summarize it, we link to where it comes from, we put the reports in there. Those day fine bills that have been introduced are on the website, they're summarized. I believe in the search function, you should be able to sort through day fines and you'll find whatever research is already out there for day fines if you're interested in learning more, and where the bills that have been introduced and what they look like. So definitely go to our clearinghouse to look for that instead of scouring the internet. It's there. And you can find all kinds of other things too in our clearinghouse. The policy documents exist in there, and cities and local jurisdictions that are doing different things. All of that information exists in there for you to sort of search through and figure out what's happening in your state. Given we only have about 30 seconds to a minute left, there's some questions in here that we didn't get to, and we'll try to see if there's a way to disseminate some of those answers, or feel free to reach out to us directly through FFJC's website, and we can, you know, answer any questions or put people in touch with folks on the panel if necessary to get further into the nitty gritty of some of these choices and decisions. But thank you all first to our panelists for joining us today and really helping FFJC to sort of ground our policy documents and the work that you all are doing. Thank you for the work that you're doing in your states. We're really excited to be partners with you all wherever and whenever we can. And to everyone who attended today, you know, just thanks for coming and learning and trying to understand a bit more about how we view these policy documents, how we view using these policy documents, as well as how we view ourselves as a resource to any of you who are looking to do some of this work in your states and your jurisdictions as you know, subject matter experts that can help you to think through the best ways to achieve some of these goals down the road. So thank you all so much for joining today, and we look forward to being in touch soon. Great. Bye, everyone.